Hi friends, in this video we are going to deal with the important judgment titled Consolidated Construction Consortium Limited versus Hitro Energy Solutions Private Limited, pronounced on 4th February 2022. This judgment deals with that operational creditor includes all those who provide or receive operational services from the corporate debtor, which ultimately lead to an operational debt. To know more about this case synopsis, please watch the video fully. The facts of the case would be that a project was executed by appellant with Chennai Metro, in the course of which the Chennai Metro placed an order for supply of light fittings. In turn, the appellant placed orders with the proprietary concern, the supplier of Thorn Lighting India Private Limited. The proprietary concern requested the appellant for an advance payment, which was paid by Chennai Metro. After some time, the project stood terminated and Chennai Metro informed the appellant that the amount would be deducted from the dues payable to it unless the amount was returned. The appellant paid the amount and intimated the same to the proprietaries concerned and requested them for refund. It noted that once the amount was released by the proprietary concern, it would indemnify them against any future claim from the Chennai Metro. In its reply, the proprietary concern stated that it would return the amount directly to Chennai Metro. Meeting was held with regard to the same. Finally, the proprietary concern noted that the appellant should obtain a letter from Chennai Metro. Thereafter, the appellant obtained a letter which was sent to the proprietary concern, but no payment was made. The appellant sent a Form 3 demand notice under Section 8 of the IBC to the respondent, which denied that any debt was owed by them to the appellant. Thereafter, the appellant filed its application under Section 9 of the IBC, read with Rule 6 of the Insolvency and Bankruptcy Application to Adjudicating Authority Rules 2016. By its judgment, the NCLT admitted the application under Section 9 of the IBC, declared a moratorium under Section 14 of the IBC, and appointed an interim resolution professional. The order of the NCLT was set aside by the NCLAT. Thus, the present appeal has been filed before the Supreme Court. The issues posed for consideration are whether the appellant is an operational creditor under the IBC even though it was a purchaser, whether the respondent took over the debt from the proprietary concern, and whether the application under Section 9 of the IBC is barred by limitation. The Supreme Court has held that Section 521 defines operational debt as a claim in respect of the provision of goods and services. The operative requirement is that the claim must bear some nexus with the provision of goods or services without specifying who is to be the supplier or receiver. Such an interpretation is also supported by the observations in the Bankruptcy Law Reforms Committee report, which specifies that operational debt is in relation to operational requirements of an entity. Section 8.1 of the IBC, read with Rule 5.1 and Form 3 of the 2016 application rules, make it clear that an operational creditor can issue a notice in relation to an operational debt either through a demand notice or an invoice. As such, the presence of an invoice is not a sine qua non, since a demand notice can also be issued on the basis of other documents which prove the existence of the debt. This is made even more clear by Regulation 72B1 and 2 of the Corporate Insolvency Resolution Process Regulations 2016. Hence, this leaves no doubt that a debt which arises out of an advance payment made to a corporate debtor for supply of goods or services would be considered as an operational debt. Similarly, in the present case, the phrase in respect of in Section 521 has to be interpreted in a broad and purposive manner in order to include all those who provide or receive operational services from the corporate debtor, which ultimately lead to an operational debt. The appellant clearly sought an operational service from the proprietary concern when it contracted with them for the supply of light fittings. Further, when the contract was terminated, but the proprietary concern nonetheless encashed the check for advance payment, it gave rise to an operational debt in favor of the appellant, which now remains unpaid. Hence, the appellant is an operational creditor under Section 520 of the IBC. Further, the Memorandum of Association of the respondent states that one of its main objects is to take over the proprietary concern. However, the respondent has produced a resolution passed by its board of directors purportedly resolving to not take over the proprietary concern. But there was no reference to the resolution in the counter statement and additional counter statement filed before the NCLT. The conduct of the respondent in bringing up this resolution for the first time before the NCLAT would lead to an adverse inference against them for having suppressed this document earlier, if at all it was in existence. In any case, Section 13 of the Company Act 2013 provides for the procedure which has to be followed when the MOA is to be amended. In cases where the object class is amended, it requires the registrar to register the special resolution filed by the company. However, the respondent has provided no proof. Thus, in terms of Section 13(10) of the Company Act 2013, the purported amendment to the MOA would not have any legal effect. Consequently, the MOA of the respondent still stands and the presumption will continue to be in favor of the appellant. Thus, it can be concluded that the respondent took over the proprietary concern and was liable to repay the debt to the appellant. Hence, the application under Section 9 of the IBC was maintainable. Further, the facts on the record would show that the application under Section 9 of the IBC will not be barred by limitation. Friends, to conclude, in this video we have seen that operational creditor includes all those who provide or receive operational services from the corporate debtor, which ultimately lead to an operational debt as per Consolidated Construction Consortium Limited versus Hitro Energy Solutions Private Limited case. In the next video, I will see you with yet another case synopsis. Until then, I take leave of you. Bye.